We are going to have a chat today about the most recent Law Commission report in relation to will making. Now, I should say right from the outset that this is in relation to England and Wales and doesn't have applicability in Northern Ireland, but our current will making legislation mirrors and reflects the Wills Act of 1837, which is the subject to this Law Commission report. So, what have you made of things, Chris?
Well, I mean, it's the most substantive review of the Wills Act in 200 years, commissioned and enacted in the Victorian era. And whilst it has met the challenges of the modern world, it also perhaps fails in certain respects to deal with the ever-changing dynamics of personal and family circumstances. So the Law Commission's quite considerable, almost 9 years in review of this matter, raises quite a number of potential changes to legislation.
Yes, I saw that the Law Commission's report itself makes 31 recommendations to changes in the legislation and produces a draft bill to the government to suggest that it's put to Parliament and reforms the entire Wills Act. I suppose we're not going to have time to go through 31 of those.
No.
So maybe take the 5 or 6 key areas. So I think the first one I saw was electronic wills, which we don't currently have.
No, we are the last remaining corner of the law that is entirely paper-based, and the paper will is the instrument. It is the document which is submitted to court for probate, and electronic signing is not something that we find in private client. So it would be quite a monumental change, but brings with it new challenges in how exactly that is to be worked out and what safeguards would be in place.
Mm-hmm. So I suppose to set out just very briefly, the current position is that, and this is the same in England and Wales as it is in Northern Ireland, that a will is not valid and does not constitute a will unless it is intended to be a will, it is in writing, it is signed by the person making the will or by someone that's directed them to do it, and is witnessed by 2 people who are present at the time that the testator, person making the will, has signed. If those formalities are not met, then it isn't a will, which automatically rules out electronic wills. So the idea here is that would reform the legislation to allow people to make a will digitally, which I think is probably a good thing because we obviously always want to increase the incidence of will making. It's better to set out what you want to happen with your assets after you die, rather than leaving it all to chance, leaving it to the statutory provisions that govern what happens when you don't make a will. But as you say, it raises its own challenges because as we work more and more remotely, we're not going to see clients in front of us as often, and that could potentially leave people vulnerable to third parties interceding on their behalf, or a will being forged, or some sort of fraud being present, because one of the key safeguards currently is that you have to be in front of at least 2 people when you do it. So there is some safeguard there. You're also quite often in front of a professional, which I think is a really, really key safeguard. I don't know about you, but I quite often find that maybe you have an elderly person in, there's maybe a third party has been involved in some way or another.
Yes.
At least meeting them in person, signing in person, I can satisfy myself that that person is giving me their instructions, that that's what they want to happen, and that I'm getting their true wishes. Yeah,
and we have clients that come into the office to execute their will, and there is a great deal of formality with that. And even as a professional, to be able to be satisfied that you have taken the instruction clearly from that client. And I think we do live in a very remote world, and whilst it might be very handy in instances for electronic signing, there would still need to be the safeguard there of the solicitor witnessing that will remotely, and that if there was a second witness required, that person, and there's a number of logistical issues there that would have to be ironed out. I don't know about you, but I'm slightly uncomfortable with that dimension, but it may just be me personally.
I agree. I find it even uncomfortable taking instructions remotely, where particularly if the client is more vulnerable. I prefer to meet them in person where I can be satisfied that they are on their own.
Yeah.
That said, it will make things a little easier, a little bit more flexible, and it may be backed up by not only statutory safeguards but perhaps some statutory guidance from the Law Commission and from Parliament indicating how practitioners can put this in place. What is good practice in this scenario? Does bring us into as well the second key thing that is being proposed, which is a power to the courts to dispense with the formality in making a will. I'm segueing to this because I can imagine as you bring in electronic wills that there will be times when people get it wrong.
Yes.
And they aren't complying with whatever rules are set out. So do you want to talk a bit about what this new dispensing power is that's proposed?
Certainly. Currently, a will that does not comply with the formal requirements of the Wills Act of 1837 is not a valid will. Even if it's very clear what a person wanted to happen with their property when they died, if it does not follow the specific requirements of the Wills Act, that will would be declared invalid. I suppose the recommendation brought by the Law Commission takes into account DIY wills or homemade wills, where someone has left perhaps a very clear document of what they want to be done with their property, but have never got around to having a will drafted by a professional, but makes very clear what their intentions were. This new recommendation, if enacted by Parliament, would grant the court the powers to dispense with the requirements currently under the Wills Act and admit that testamentary document in the same way as a formal will would be.
I personally am for there being a dispensing power. I think strict compliance is pretty archaic, and whilst it's there clearly to safeguard people from a forged will or from fraud, by ensuring that it's made in the way that it is and that it is not valid without it, it does potentially lead to situations where if there's a professional not involved, if there's a professional involved, you'd expect that the formalities are met.
Sure.
Because that's part of your job. But if there's not a professional involved, people get it wrong, and there may be nothing inherently untoward with what they're trying to do. They just get it wrong, and under the current rules, it's just not allowed. It's just not a will. So this would allow, a form of substantial compliance where you can tell the person has tried to comply with what is required to make a will, or they've clearly intended to make a will, but haven't been able to do it, and it allows the court to use its discretion to find that a valid document rather than essentially just saying this isn't worth the paper it's written on.
And other jurisdictions do have dispensing powers, Canada, Australia and New Zealand. Exactly. And the Law Commission's report has indicated that even with this dispensing power, it hasn't given rise to substantial litigation. Litigation levels remain standard levels, so there wouldn't be an excess in court time being left to these matters.
Absolutely. One of the next recommendations that's come in, which is quite an important one, and is one that quite often people are very surprised to learn about, which is the effect of a marriage on a will. So under the current regime, if you enter into a marriage after you've made a will, the will is automatically revoked.
Yes.
Unless the will includes a provision which says that you've made it in contemplation of that marriage. Not really good enough to say I'm making this will in contemplation of a marriage to anyone at any time. No. It has to be in your mind that you're getting married at a certain point in the very near future, and you know who that person is for that to be effective. So the current position is that would revoke your will, which would leave your estate to be administered under the rules of intestacy, unless you make a new will after the marriage. And under England and Wales regime and in the Northern Irish regime, the spouse is put front and centre when it comes to succession and inheritance. So if there's no will, your spouse automatically gets the right to administer your estate and also gets the right to the first bite at the cherry with the assets, and always shares in what's left of the assets at the end.
Yes.
So it's really important that this is looked at, because there's been quite a rise in what's being termed a predatory marriage.
Yes, and one of the things the consultees from the Law Commission discovered when they were obviously taking the views of the general public, that most people are not aware that a marriage will invalidate a will. And you can certainly imagine an instance where as you say, a predatory marriage situation. Someone may feel because they have made a will that their affairs are taken care of, even when marrying again. And that can lead to quite heartbreaking situations for families in those particularly nefarious circumstances. And the court has obviously, the Law Commission, will have taken a view on how do we safeguard people in those situations. And one of the safeguards would be, whilst there may be a nefarious person who enters into a marriage for their own gain or to take advantage of someone, you may ask the question, well, what would stop them then just taking them to a solicitor and having a will made? But the very fact that they would be coming before independent professional who would be cognizant, especially post some of these changes, why this legislation is there in the first place. A professional solicitor would be able to be perhaps more attuned to some of the dynamics that would be going on, what the circumstances are, being able to take a background of the testator and perhaps be able to either give advice in that instance or provide a very good attendance note of advice has been given and perhaps ignored. And this is, of course, taking into account the changing social fabric where people are either marrying again in later life or perhaps even in instances where there's no nefarious element, where they're perhaps cohabitees for maybe 30, 40 years, have made wills that reflect their desires to leave their estate to each other, perhaps they have children as well, and then down the line marry, and that invalidates perhaps the work that they have already done. So you can see how when the Wills Act was enacted in the Victorian era, marriage, very perhaps a straightforward affair, does not take into account some of these changing dynamics here.
Absolutely, and I think a really important bit as well is that what a lot of people don't understand is that not only does the marriage revoke the will, but if the party to the marriage that was maybe the victim of a predatory marriage subsequently dies, you cannot, in most circumstances, invalidate the marriage to restore the position. So you don't have any recourse.
None.
There is nothing you can do. Or very, very, very little. There's still inheritance claims that can be brought in, but that's a bit of an uphill battle for a lot of people. So it's not something that's easily set aside and undone. So this, I think, is going to be a very welcome change. But getting on that point about influence, the Law Commission has also recommended enabling the courts to deal with undue influence a little better. Undue influence, of course, is what some people have used the old form term of duress, where someone has been coerced into making a will. A third party has intervened. They have basically supplanted that person's wishes for their own, and the will reflects really what that person wanted to happen and not the person making the will. So in the current rules, it's all based in case law. Case law basically says that if there must be actual coercion, and that can be quite a tricky thing to prove, for a will to either be set aside or for certain provisions within the will to be set aside. This new recommendation is to give the courts a statutory authority to deal with cases where they believe a person was subject to undue influence in order to safeguard vulnerable people. I don't know if have you come to grapple that issue yet? Any thoughts on it?
Well, I've always been of the view that the undue influence aspect of will validity was always a mountain to cross, and unless there was concrete evidence that could be brought before the court, it was very unlikely whether an applicant in those circumstances would be successful. I think giving the court a statutory power to be able to infer that there has been undue influence exerted, and to be able to find any reasonable grounds to suggest it, obviously in court proceedings, to really give effect to undue influence, which sort of I think has become such a monumental hurdle to get over that where there are, as the Law Commission says, reasonable grounds, the sort of the concrete and very restricted provisions within the case law at the moment leaves very little wriggle room for far more subtle and far more perhaps sophisticated ways in which someone can take advantage of an older person. And this particular aspect of the proposed changes, legislation recently passed on this subject, is at present sort of almost contradictory to the Banks and Goodfellow test for the Mental Capacity Act. Perhaps you could speak to some of the differences in how both of those pieces of legislation at present are not exactly in tune.
Yeah, and that's another point that the Law Commission is looking at, is trying to homogenise the position on mental capacity when it comes to making a will, because currently in England and Wales there's a piece of legislation that's been around about 20 years that sets out the test for capacity for most things, which allows is meant to really enable the incapacitated person to make decisions and to assist them with making decisions rather than just finding them incapable and making decisions for them. That legislation has been around for about 20 years in England and Wales. We have something similar that's come into effect in Northern Ireland. Sorry, it's been passed in Northern Ireland but hasn't come into effect for the most part. But there is still a different test for making a will. Yeah. So you have a test that's based case law from 150 years ago, that sets out the test for making a will. That hasn't really changed. It's been supplemented over the years. There's a body of case law that has grown out of it, but it is not based in statute, and that's certainly the position in Northern Ireland. And there's been a bit of an argument in the case law in England and Wales as to whether or not the Mental Capacity Act test is meant to apply, or if the Banks and Goodfellow test in the case law is meant to apply. And this proposal would help to try and deal with that issue and to provide a comprehensive code of practice to practitioners dealing in this area to understand what's the best way to assess someone's capacity, and those guidelines would be very, very useful. I expect that they're likely to echo a lot of what the case law has been over the last 150 years, and it would be good to see those codified into one place. So you'd essentially have a checklist that allows you to work through that with someone and ascertain, do you think that they're capable? Do you think that you need a medical practitioner involved? And can you proceed? So it's that'll be a very important thing to see come through as well. And those are really the key points that we wanted to address today. I think the key thing to really highlight to people, anyone listening, is that this is currently a proposal from the Law Commission. Nothing's actually been enacted. It's off to go to Parliament and to the government to go through committee and readings, etc., for them to work out all the issues and decide whether to pass it. And even when it does pass, it's in England and Wales, not in Northern Ireland.
And it may take a while to get from Westminster to Stormont, so we could be at retirement stage by the time this...
It'll be interesting to see if Stormont takes any notice. But that is the height of what we wanted to talk about today. So thanks, Chris, for joining me.
Thank you, Daniel.
If anyone needs any help with any of the issues coming out of this podcast, discussion about making wills or discussing your estate planning, all of our details are online. You can call either of us. We'll be happy to chat to you. Thank you.
Thank you.